slide speaks to, and I will also be making sure that I emphasize those key areas that I think are very important for us to look at from a, from a presentation perspective. So let me know if you can. I hope everybody's seeing the slide very well. So for today, we are looking at, at a high, can everybody see this at, in a very big font? Is it coming up very, very big? I want to know if the slide is.
Yes, we can see it.
Okay, because mine, okay. So the first slide is, we are talking about the preamble. So what we want to do here is to look at a high level, what we will be doing today. So what we will be doing today is to look at the role of contract law, its element and principles in competitive bidding and tendering. Then we will also be looking at the two sides of the contract that is related to competitive bidding and tendering. We will also consider the specific nuances that affect competitive bidding and tendering law activities in Canada. My expectation is that I will be going into the key legal differences between contract A and contract B. I will also be looking at the key differences between, what is a tender and what is an RFP. In the course of my research, I have found out that, purchasers and owners of contract and projects have consistently misused these two concepts. Even though they look alike, there is a great legal distinction between two of them. I will also be looking at the implication of bid instructions, also the duties and obligation of purchasers and remedies are available. For every webinar, there is always a takeaway and what is a need for us. And that part will be coming in terms of who is impacted by competitive bidding and tendering. Is it just the public and private entities or both of them? We'll also be looking at the risk and impact that will also bring. And then from a knowledge perspective, what are we gaining from this going forward? So my first slide will dwell more on what is competitive bidding and tendering. And I define this to mean competitive bidding can be defined, using these following simple analogy. It is a process by which a party issues an invitation to another party called the second party, expecting that second party to express interest in terms of providing either goods or services. So the way I have described it is a process of issuing a bid by an entity. So an entity will be the first party, which happens to be the company. In these slides and in this training today, we'll be referring to that entity as the owner, with the intent from that owner to the other entities, which is the company's contractors or organization, asking them to put their best proposal and then compete for a specific project. So the key thing there is that there is a party who is issuing an invitation to a second party, which should ideally be the vendor, the contractor, or the supplier, expecting that supplier to put in, their best, tender or proposal in order to win that opportunity. So the process in these guys, simply means that the process therefore creates a transparent environment that is open and fair. The essence of it is that when there is a competitive bidding and tendering, the essence and the integrity of it is very, very fundamental, because the purpose behind it is that they want to play and then give equal playing opportunity to those who are going to participate. So what that means from a participation perspective is that any entity, regardless of your size, annual revenue, you will be welcomed, to take part in the bidding process, and then you will be given fair opportunity of the likelihood of you winning the bid. So having said that, then the next thing we need to look at is, like I said before, definition. I have already defined it. Which other way can we also define competitive bidding and tendering? In here in my slide, I kind of define it as a process by which an entity, an owner or purchaser, wishing to have an assignment completed, e.g. a project, goods or services, then engages a second party, in these circumstances a contractor or supplier, of which there is the intention from the first party, which is the company, to enter into a legal, binding, and enforceable relationship called a contract, of which once they enter into it, that purpose gives that first party, which is the company, opportunity to ask the second person to solicit to provide the goods or services to the first party. So it moves from the first party to the second party, and for the second party to put in a request, best request, depending on what the terms and conditions will be, in order for the second party to provide goods or services to the first party. If you look at this definition, there are key things that keeps coming out, and those are the things that I highlighted in red here. I said in both definitions, there are some elements that are very consistent and constant. What are those elements? The first one is there is an intention of two parties to do something together. The first party, which is the company, already expressed interest to invite a second party, and the second party is desirous of going into that relationship with that first party. So there is an intention between two parties to do something together. It is also, in the definition, there is an anticipated exchange of value and consideration. So when the first party and the second party comes in, both of them are expected to give each and every one of them something in return. And most importantly, in that exchange, there is going to be a reward. First, there is intention. The second one is the exchange of value and consideration. And the final one is that of a reward. Having said that, the next thing we have to look at is the fundamental principles that has been created out of this definition of what is called competitive bidding and tendering. Like I did say before, competitive tendering and bidding is a process by which a party issues out an invitation to another second party, expecting that second party to solicit to render goods or services to the first party, of which the relationship with them will create a binding relationship. So out of this definition, key things that I've been able to highlight here in this next slide are the fundamental principles and the elements that are consistent in the definition of competitive bidding and tendering. The first one is what I call the first principle: creation of legal binding enforceable contract. What I'm saying here in this slide is that when that relationship of competitive bidding and tendering, comes up, there is a creation of an enforceable contract. That act of the company asking the second party to solicit to provide services is creating what will be called and considered as an enforceable contract. In the course of this slide, I will be going into much details. You can see some of the bullet points that I've already highlighted, but I wouldn't want to dwell on them right now because those are the areas where we'll be laying more emphasis. So apart from this first principle, there is also a second principle that flows out of the definition of competitive bidding and tendering. And that second principle is what I call bids and tenders must be compliant for the first principle to take effect. So the first principle is saying that when that situation arises, a legally binding and enforceable relationship is created. However, the second principle is saying that for the first principle to be effective and legally binding, it must be done in a compliant way. Compliant way means that if there are conditions, what in law and in contract management or in contract drafting we call terms and conditions, means that for that bid or soliciting of bid from the second party to be effective and acceptable, it must meet the conditions and requirements that the first party, which happens to be the company, must put in place. Also, as I have also stated here, I have also provided some guidelines of what will be expected in such a situation, but I will also have opportunity of dwelling on that, because of time. Then, beside the first principle and the second principle, there is also a third element, which is called the third principle. And that third principle is called obligation and duty of fairness is created. So when a competitive bidding process is taking place, it automatically, beside creating a legally binding relationship and ensuring that that relationship must meet the conditions set by the first party, it is also expected that a third principle is created. And that third principle is that there is a duty and obligation under the law expected of the owner of the project to exercise what is called duty of fairness. That fairness speaks to the integrity, that fairness speaks to equity, that fairness speaks to natural justice, and that fairness also makes sure that any discriminatory practices is eliminated from any relationship that is created out of competitive bidding and tendering. At this stage, before we move to the next slide, I will want to know if anybody has any question. Otherwise, we will proceed. Does anybody have any questions so far?
Yeah, thanks, Afam. That's really a great introduction there. Just as you have mentioned, we will really appreciate if you have questions at this point. I do really feel like we already kind of dive deep into this, and so I'm expecting people to have questions around the things that you have talked about so far.
Okay. In the absence of that, so in the absence of any other questions, so we've looked at the definition of competitive bidding and tendering. We've also looked at what elements are created when is a competitive bidding and tendering relationship comes up. So having talked about the first principle and also the second principle and the third principle, there is something that I feel begins to add up here. And that thing that adds up is what I framed in the next slide as what is it that jumps out to you, having reviewed or having seen a little bit of the presentation that I've made so far with respect to this. And that brings us to that question, presumptive overview. I call it presumptive overview because when we are faced with a scenario and things are unfolding, our minds begin to race around. We begin to think, you begin to apply that, that knowledge and intelligence, analytical skills in terms of interpreting what is the situation happening here. I can't really get what is happening here. What would this pan out to be? How are we going to, resolve this problem? So my question here becomes, what has jumped out so far? And I have a tip. I say, if something sounds common sense, people will ignore it. However, something that is common is not always common. And for me, what has jumped out so far from my definition of competitive bidding and tendering is, one, there is element of law of contract in it. Because you will remember that I say that competitive bidding is a situation where a party A issues out invitation to another party, out of that relationship, it is expected that the first principle will exist, which is creating a legally binding contract. And when we talk about legally binding contract, we are emphasizing, if not aligning ourselves with the principles of laws of contract. Then another important thing is this. The second part of it is the common law principle and perspective of it. What is the common law principle and perspective of it? I will be dissecting these two areas that are very deeply embedded in competitive bidding and tendering. And this is why the slides and this is why the seminar is going to be very interesting. So I say that the connection here is that competitive bidding and tendering process creates a legal relationship, which is a contract that is enforceable and binding on the party. And the contract is also governed by a set of elements and principles together with common law decisions. So what I'm trying to say here is that the relationship that is created out of the contract is governed by a set of principles, and those principles are things that flows from what we call the common law. I know the first question that will be coming into everybody's mind who is not a lawyer is, what is common law? That's why it is interesting for us to go to the next slide. I will do a quick drive here, which is a quick dive. Let's now quickly consider these two things that jumped out at us under the presumptive overview. One is the contract law or law of contract. What is contract law? The next slide will be taking us to what is called Contract 101. I will be looking at, a very simple definition of what is contract and what are the basic elements of a contract, so that from a contract management and legal perspective, we will be able to know when either we as an individual or representing our own employers goes into a contract relationship, so that we'll be able to know whether what we are going into is a contract or not. I will also be defining what is common law in the next slide. So contract law and law of contract. Contract is a type of agreement. I have to first of all define what is a contract before I go over to what is called a contract law. That's the way we do it in law. We say we lay a foundation before you move to the next stage. What is contract? Contract is simply a type of an agreement between two individuals that is legally binding, by which parties express the interest for them to exchange consideration and for there to be a reward. It is legally binding. Parties to the contract must intend for the contract to become binding when it is accepted by the other party. Having said that, the next thing is, what is law of contract? Contract law is a body of laws that govern, enforces, interprets agreements related to an exchange of goods and services, properties or money. If you take your mind back from the first definition of what is competitive bidding and tendering, you will begin to see that those things we highlighted under the presumptive overview, which is law of contract and common law, are beginning to come up again and again and again, showing that in competitive bidding and tendering, we cannot take ourselves away from element of contract and the element of common law. I have already defined what is a contract. I've also provided a meaning or definition of what is called law of contract. Then the next thing becomes, what is common law? People have heard about this common law. What does this really mean? Abiodun, while I'm doing this, I might be carried away with this. This is something that I find very interesting. So I will also like to be very mindful of time.
Sounds good. Yeah.
Yeah. What is law of contract? There are basic features that everyone who will be or is engaged in competitive bidding and tendering should know about. Basic features of law of contract are: it is an agreement, it is binding, it is made between two or more parties, including businesses. There is a promise to do something in return for a gain or advantage. And most importantly, there is an outcome. What is that outcome? It is legally binding and will be governed by the law of contract if a breach exists. And that breach is not exempted when it comes to competitive bidding and tendering, meaning that in competitive bidding and tendering, there is potential to be a breach, sorry. How that breach happens is also why this slide and the webinar is very interesting. I've already talked about the element. There are 5 basic elements of a contract. First is the offer, and the second one is the acceptance, and the third one is the consideration, and the fourth one is the capacity, and the fifth one is the consent and the lawful purpose. But why these elements are very important, I want us to focus on the first one, the second one, and the third one, because they tie back again to what we've defined so far in competitive bidding and tendering, because you will hear me say a lot that party A is offering party B the opportunity to do something, and party B is saying that I'm willing to do it in an exchange for a benefit or an advantage. In the next slide, I talked about the element of a contract. I defined them. An offer is made that contains all the important and relevant terms of the contract. The second one is actually the acceptance, when the second party now decides to say, okay, I take you on your offer, I'm going to do that. And then the third one is the consideration, which is the most important. It is most important because at that stage, you're expected to perform your own side of the obligation, and the other party is also expected to perform their own side of the obligation as well. Then what is common law? What is common law? I just want to give an opportunity to see if there is somebody, one of the participants who can, tell me what is common law. That might also be helpful.
That's a good idea, yeah.
Okay. Common law is, the simplest way to define a common law is a set of rules and judgment that has been handed over by judges as a result of court action or suit filed in court. So when myself or Abiodu happen to go into a contract relationship and there is a breach, the resulting impact of that breach is that either Abiodu will sue me to court for misrepresentation or breach of promise or breach of contract, or myself will sue Abiodu. And when we go to court, if we go to court, there is what we call in law judicial precedent. Judicial precedent is a situation where judges rely on earlier judgment, provided by court of higher jurisdictions. Court of higher jurisdiction in this sense means that if you sue somebody at a lower court, I don't want to use the Canadian court system because I'm not a lawyer here in Canada. I would prefer to use the court system that I was called to bar on, which is the court of Nigeria. If you sue somebody at the High Court of Nigeria, I will, as if I'm a judge, I will not be relying on the decision of a similar contract by a judgment issued by the same level of court. Take, for instance, a judge in another state provides a judgment relating to something similar to what issues that I have in the same court. That judge is not required to use the same precedent, but that judge may be required to use a precedent set by a court of appeal. And if a court of appeal wants to rely on a judgment, they will rely on the judgment issued by the Supreme Court. So common law historically flows from England, common law of England, where judges rely on decisions and rulings or judgments made previously by other courts of higher jurisdiction, to rely on that to use it as a reasoning in terms of their judgment and the reason behind that. Then what is the position of common law in Canada? In Canada, the law governing competitive bidding and tendering is informed by several categories of legal rules. However, from a historical perspective, the historical foundation of competitive bidding and tendering in Canada flows from common law or judge-made laws. How? The first question somebody will ask is why? If we're saying that competitive bidding has something to do with element of contract, why does it mean that there is no written rules or statutes, put in place by the House of Commons or the Senate, having been passed into law? Is there nothing to that effect? I wouldn't say there is none, depending on the perspective that you are looking at it. Because if we are talking about public procurement, there is element of legal rules that has been passed on that should be guiding procurement in a public setting. But because we are talking about competitive bidding, which cuts across all corners, predominantly in Canada, the principles relating to competitive bidding and tendering was actually set down through common law. So what are those common law? The common law precedent, I call it common law precedent, meaning judgment that impacted competitive bidding and tendering, are basically 3 in number. I say these 3 in number because each of them had different principles that they set in place. So what are those common law principles? What are those common law decisions that, set the precedent for competitive bidding and tendering law in Canada? The first one is the one called the Queen and Run Engineering and Construction. It's popularly called the Run Engineering. Then the second one is the MJB Enterprises Limited and Defense Construction 1951 Limited. That was 1951 was when actually this law was put in place. Then the other one is the one called Matadale Building and Limited and Canada. So in these common law cases, there were specific precedents that occurred. I will be going into those ones and I will be providing more detailed information with respect to that. The first one is the Queen Ontario versus Long Engineering Construction. This is and remains the first Supreme Court of Canada decision that today defines Canada competitive bidding and tendering law at common law. Why? Because it was the first Supreme Court decision that introduced what we call today a contract A and contract B relationship. It simply means that when a company solicits for bidders to put in their tender, that solicitation purpose or solicitation process creates what is called legal and enforceable contract. And I want to take you back again to the previous slides where I talked about the fundamental principles of competitive bidding and tendering, where I highlighted on 3 key principles. The first principle, creation of legally binding and enforceable contract. The second principle, meaning that for the first principle to exist, there must be a situation where the bid or the tender put in by the second party must meet the conditions or must be compliant with the conditions that party A, which is the owner of the project, must have set in place or must have issued in the invitation to tender notice published publicly. And the third one was the one we talked about, creation of an obligation or duty of fairness on the owner, meaning that when the second party has put in a bid or a tender, you owe that second party and every person who has indicated interest what is called a duty of care to make sure that integrity is in it and that you are not using it as an opportunity for bid shopping. So apart from the principle of contract A and contract B, which I will still have opportunity of going into in details, what are the other things that the common law cases that I earlier presented, talked about. And that will take me to, this slide is still talking about what are those principles that the Quain and Ron engineering introduced. Here I talked about, expects the owner will award the contract based on the completed tender documentation alone. It also says that when the owner of a project requests that parties solicit, the essence of it is that you, the owner, you should award the contract based on the terms you've issued in the invitation or call for tender. You must also not negotiate with the bidders, and the evaluation criteria must be set out before the date of the award opening, or the date of the bid evaluation. So what it means is that in the notice that will be published, expressing and asking people to express their interest, or asking the second party to express their interest, you must ahead of time put what you will be using as a criteria for evaluation of those who will likely be winning the bid. So what that does is that it eliminates opportunity for surprises, so that you don't come in and then do things the way you want to do it because you feel that you can do that. So I also talked about contract A paradigm here and contract B, but let me not dwell on these very slides, and let me go to, I will come back to these slides, but I will go to the second common law case that ushered in, or kind of, created a good solid foundation for the existence of competitive bidding and tendering. So beside the Ron engineering, the second one is the MJB Enterprises Limited and Defense Construction. What did this case do? In this case, the court established the second principle, and that second principle is that bids and tender must be compliant for the first principle to take effect. And secondly, it says that contract A only comes into effect when a compliant bid is submitted. And more importantly, he also said that contract A will not always be formed. So he's saying that the mere fact that a party, which is the second party who indicated interest by submitting a bid, the mere fact that you submitted a bid does not mean there is a relationship that is already created. So in the first principle says that once a bid is submitted, a legally binding contract is created. The second principle established under this case, which is the MJB Enterprises, is saying that a bid must be compliant. So there is a connection between them. First is that a relationship is created, but for that relationship to exist, you must know that the bid that created the first relationship must be compliant based on the condition that has been set in by party A. Then, what is the third principle? The third principle was set in in the case of Mattel Building Limited and Canada in 2003, where the Supreme Court enshrined the principle of duty of fairness. What that thing is saying is that it is expected that as a company, that every bid must be treated equally, and the bid process should not be used as an opportunity for bid shopping. Bid shopping simply means that where you expect people to bid and then you use opportunity for you to negotiate with them. I need you to pay attention to what I'm saying here, because this will form the basis of our distinction between what is called tender and RFP. You will recall that during the beginning of the slide, I did emphasize what will be the outcome of this learning. What are we going to focus on? And one of the things I mentioned is the distinction between RFP and tender. Before I move back to the first principle, which is the principle established under Ron engineering, where I will be diving into, doing a deeper dive into contract A and contract B, and then working it back again to the second principle and the third principle. I will want to stop here to see if anybody has any question, because I think this is a good place for us to really separate the wheat and from the weights. So this is a good platform for us to be able to narrow it down to the nitty-gritty. This now becomes the fundamental element or fundamental part of the webinar, where we will now be focusing on what are those things that the common law has set in place with regards to competitive bidding and tendering, contract A and contract B, and how the principle in the first case and the principle in the second case and the principle in the third case aligns together to create what is called the Canadian system when it comes to the competitive bidding and tendering. I would like to stop here to know if we have any questions so far.
So there is a question here from Dayball.
Okay.
Saying, can you define tender, please? Okay, so I think you mentioned call for tenders in the third principle there. Maybe that's what he's referring to.
Yeah. So tender can be defined as, depending on where you are coming from. If you are coming from the first party and the second party, and let me make it very simple. So a tender will arise where there are two parties. The first party is myself. I will use myself as an example. And the second party is yourself. So I am a company. I am the owner of a project. I have a project. I have an atomic or nuclear energy dam that I want a contractor to build for us. That's me identifying a need. Then I will be issuing what is called invitation to tender. That tender is, meaning from me, a tender is a notice of intent expressing expectation that I would want another party to tell me what it will cost them to build that project. So the first tender is from me, which is called invitation to tender. So a tender is an information issued by a party that speaks to the requirement of that party, or if it is coming from the second party, how the second party will fulfill the obligation or expectation of a contract that the first party desires a second party to perform for it as a company. Does that make sense?
Yeah, I think what I've, I think to put it into the Canadian context here, there's a use of these languages, interchangeably. Some people will call it tender, some people will call it bids, and I think it's good to put that into context, because what I've really also observed is that tender is a language that is very common in the construction industry in Canada. Whereas when you go to some other industry, they will rather use maybe quotation, or they can use a lot of different languages out there. So maybe that's where that question is coming from. But I do, AFAM has been able to explain it on a legal definition basis. But when it comes to the industry parlance, there are ways that people use to refer to these things that kind of create confusion for people who might not really be into the contractual or legal aspects of these documents. So I think we have another one here. Apart from the common law, is there any other generic normative documents and acquisition procedure in Canadian public procurement? That's a good question.
Say that again.
So aside from common law, is there any other generic normative documents, or maybe, let's say, fundamental principles, that relates to acquisitions procedure in Canadian public procurement? So as of today, now we're talking about common law, and then we're talking about competitive bidding law. Like, are there any other procedures or legal procedures or anything of that nature that also forms part of considerations in Canadian public procurement?
Yeah, thank you so much to the participant.
That's from Deji.
Yeah, Deji, thanks so much for that question. And I really appreciate that question, because the reason why I appreciate that question is that there's a thin line between what we are doing today, which is competitive bidding and tendering, and how it crisscrosses between private and public. You will understand from my introduction, I did emphasize that one of the things we will be learning here is who is impacted by this process of competitive bidding and tendering. To answer your question, yes. Beside the common law, there are lots of legal rules that relate to public procurement. I wouldn't want to dive into them a lot, to avoid, moving that, because that's an area I find very interesting. But I will give you a highlight. One is there are lots of statutes that are there, administrative statutes, like criminal code that speaks to that, the fact that you should not engage in bribery. If you do that, you will be penalized for engaging in that. So there is an administrative rule that says that how you should conduct yourself, code of conduct that has been set in place, ethics rules that has been set in place. That's why some time ago when our Prime Minister engaged in some activities, he was actually reported to know if he breached the code of ethics rules, and he was reported to the ethics commissioner. The reason for that was to know if public fund was used in an inappropriate way. Another way that, one of other means that regulates, if not governs, acquisition of goods and services in the public agency or public sector is fundamentally the trade agreement. It is a huge part of public procurement, such that you can hardly do anything in public procurement if, depending on where you are working from, if you are working for the federal government, if you are working for the provincial government, if there are trade agreements that they are party to or signatory to, it is expected that the obligations that are enshrined in those trade agreements must be followed from the period you've identified a need to the period that you'll be engaging in a vendor. That will be another conversation for another time, because
there
are lots and lots of areas to learn, interesting fields to learn in trade agreement and public procurement, and why it is important to distinguish between public procurement and private procurement. And being someone who provides compliance and regulatory compliance management directive and support and assistance to the procurement department or business unit where I work, I have seen people kind of mishmashing these, bringing, wearing the cap of private procurement into public procurement without really understanding there is a huge dichotomy between them. But that would be another webinar for another day.
Yeah, thanks. I actually wanted to say that that's really another area entirely by itself, where the interesting thing about the trade agreement that you just said now is that it sets its own rules, around this competitive bidding, such that if you are working in the public sector, it's like you have another barrier, that you have to really cross. This thing is really complicated, honestly speaking, and it will take some time for it to really sink. Even the one we're talking about today, which is the competitive bidding law itself, this is like the first three, what do I call it, case laws that kind of throws us into this whole thing. But then there are still other case laws that came after Mattel building, and the ones talking about bid shopping, the one talking about subcontractors, how you deal with subcontractors. I mean, there are many of them. So all of these also do have impact on public procurement, and depending on what process or what kind of transactions you are dealing with in the public sector. So any other question, guys? I think there are still a lot of things that I believe that Alpha wants to talk about, but we're almost out of time here. I will just leave it for anyone else who still has a question, so that we can take care of that, and we can then close from there. Because I mean, if we continue, I mean, we're not going to finish like like in the next 1 hour, as I suspect. So, but is there any question? Any question? No, we're all good. Advice for procurement professionals transitioning from private to public sector. So it's asking if there's any advice for people who are transitioning from the private to the public sector.
Yes, there will be there are lots of advice that I will offer, but like I said, public procurement is an entire specialist field that I will always recommend people to have quite a good knowledge of. One of the advice I have to provide is that public procurement requires that at every point in time you have to do a risk management, because there are lots of risks that are involved, and those risks are one of the things that I highlighted. You are dealing with reputational risk in the event that an agitated vendor happens to file a complaint against your government entity if you work for the government, and there are potential fines that are associated with it depending on which trade agreement that you are looking at. Are you talking about the Canadian Free Trade Agreement? Are you talking about New Western Partnership Agreement, which is the NWPTA, or are you talking about Comprehensive Economic Trade Agreement? And there are lots and lots of trade agreements. So you have to deal with the element of risk management, and public procurement is all about compliance. You need to comply. You need to understand the rules. You need to know what you need to do, how to engage a vendor, and most importantly, the duty of fairness, the duty of integrity, non-discrimination, open and in competitive way. You have to source the goods from a competitive manner unless an exception exists. So I have mentioned it that one of the key things is knowing about the risk management. What are those key risk management? What are those things you should watch out for? Like I said, public procurement is an entirely new, different webinar that we can also do to provide that knowledge. But I hope a few of these things that I've provided are key things that you should watch out for.
Yeah, especially for those who probably might be having, let's say, interview with the public sector, and they ask them questions pertaining to these things. I would say, you can explore these on your own to see what you can come up with. But definitely, I say that to really be grounded in this type of information requires experience. Somebody who really have seen all of the different permutations through which, contract terms and conditions in the tender documents might be interpreted. So, sort of saying that you need somebody to actually guide you. So, we'll be talking more further with AFAM to see how it could assist in this area to provide further deep dive into the contract, the competitive bidding law in Canada. And there are still other areas, of course, that we can really, have him to provide some further education, enlightenment on that. So if there are no any other questions, I think somebody's asking here if you'll be sharing the slide. Yeah, I will. I think we would have AFAM. Is it something you're able to share the slide with the attendants?
I would prefer to, do a takeaway, because I know I invested a lot of time into this, but I think it is also something that I will be willing to, because there are lots of information here that I feel that will be of benefit to people who, so it's something that I'm considering to do, but we can do that offline, once the seminar ends, so that I can rush through some of the key things. So in the absence of any other question, so I need to now dwell on contract A and contract B. Contract A and contract B was first set in under the first principle. So what is contract A and contract B? What he's simply saying is that at the point where you begin to engage in competitive bidding and tendering, the key thing that you need to bear in mind is that once you issue out a tender or a call for tender or invitation for tender, which is tender or bid is being used interchangeably in the industry. It means that you are asking for a legally binding contract to be created. Once the second party, which happens to be the contractor or the vendor or supplier, sends in their bid within the period required, once that bid is sent in, and if that bid was sent in a way that is compliant with the conditions that the company has included or set out in the invitation to tender or call for tender document, automatically contract A is created, and that is called process contract. What it simply means is that you are already bound to honor that bid. If you breach by not following the required procedures you've set out in your call for tender document, a party who in this case is a vendor or a contractor will legally sue you in court and will be entitled to remedies. So when a company issues out a tender for bid, issues out an invitation for tender, and there is a response to that invitation to tender or bid for a call for bid, there is a contract that is created. That contract that is created is called contract A. If you breach it, it will lead to the contractor asking for damages. That's what contract A says. So it becomes very important, because of time I have to now summarize. It becomes very important that for us as procurement professionals, when we are acting on behalf of a company to manage a bid, we should ensure that the terms and conditions that are included in the invitation to tender or the bid or call for tender document must be well scrutinized, and the terms and conditions properly and highlightedly reviewed to ensure that there are no issues or opportunity for doubt, because that's where integrity starts to come in. Having talked about contract A, what is contract B? Contract B is simply saying that immediately a company asks for contractors to submit a tender, and that tender is submitted, when there is a review of that tender, upon the review of that tender, depending on what the criteria for the award of contract will be, the actual contract that the winner of the bid enters into with the company is called contract B. But very importantly, you cannot have a contract B if the principles of contract A is not respected or abided with or complied with. You will remember when I talked about the first principle that says that when a bid is submitted, hypothetically or technically from a legal perspective, a contract is created. However, in the second principle, for the contract A to be effective, the bid must be compliant. And it's not in every situation that a contract A is created. So for a contract A to exist, it must be submitted, it must meet the requirements set in the tender notice, and where the contract B will now come in place is when that tenders are being reviewed and evaluated. The company that has the best value, most precisely in this situation, best value means in terms of price, will now be awarded a contract B. Then it becomes very interesting that if an agitated vendor or contractor feels that the principles set or the rules set in the tender document was not followed by the company in doing the evaluation for which the award of contract B was issued to another contractor, that is where that element of contract law, that element of common law will now come up, because that party will now sue the contractor to court. Sorry for that mistake. We sue the company to court, asking in different ways that they believe that they would be entitled to a remedy, either because the person who was awarded the contract may have submitted a bid that is not compliant, or that the company deviated from the principles that they've set in contract A, which is the tender document or invitation to the tender that they issued out. I want to emphasize once more again here that when we talk about contract A, we are talking about the invitation to tender or call for tender document that the company issues out asking prospective contractors to submit their bid. That document is very important. That document is what governs the relationship that you need to create in the second contract, which is contract B. Where you deviate from doing those things that are enshrined or included or set out in the contract A, contract B will become null and void because it will be subject to challenge. Having said that, I want to quickly rush through the slide because what contract A will have, information that should be included there, why it should be included there is very important. And I need to also emphasize here that one of the key principles that we need to watch out for in competitive bidding and tendering is that when you issue a call for tender under contract A, two things must be obeyed or respected. You must stick to the rules and the conditions that you've stated that you will use in doing the evaluation. Secondly, you must not give opportunity for that to be negotiated. Thirdly, if the bid is non-compliant, during the evaluation, you discover that the bid is non-compliant, there is what is called no mercy rule. Do not even bother to ask the person who submitted, the company that submitted the bid, to ask them to provide clarification, because that will be deemed as not being fair. So once a bid is not compliant, either by time, either by not quoting their price value properly, reject and move on. Because if you give them opportunity to correct that error, you are breaching the third principle, which talks about duty of fairness and care. In the decided cases that I've, in my research, I have reviewed, I found out where a party submitted a bid and they made a mistake in terms of the calculation of their GST, and they had the lowest bid. And the company gave them opportunity to come back and do their review and then acknowledge that it was a mistake before they were awarded that contract. When they went to court, it was found out that the contract B cannot stand because there was a breach of contract A, which is that they gave people opportunity to negotiate and the bid was not compliant and shouldn't have been received in the first place. And I'm going to take you back again to those principles because I like laying foundation as we do in law. First, the principle is that when a bid is submitted, a legally binding contract is created. For the second principle to exist, the bid must be compliant. In these circumstances, if the bid is non-compliant, you have to apply the no mercy rule, which is do not even accept it and move on. So
Thanks,
sorry?
Yeah, thanks. There's a question here. So aside from late submissions, what are the other compliance policies that can result into bid disqualification before bid evaluation? I think this probably kind of sums it up, in terms of the contra A rules, right? Or is there anything you want to add to that?
So let me hear the question once more. Because
so it says, what are the other compliance policies that can result into bid disqualification before evaluation aside from late submissions? So if you are applying the no mercy rules that you said here, does it have to do with just late submission, or there are some other issues or some other policies that we have to observe aside from late bid submissions or some minor errors? Because really what I wanted to add to that also is the fact that sometimes there are some errors that are not considered to be errors that directly impact the scope of work, for example, are not considered to be. So what do you say to that? Because when it comes to the practicality of these things, if I have to, sometimes in public sector, we end up with just maybe 2 bits.
Yeah.
And then if I have to disqualify one, then it's like I'm not having a competitive bidding, right? So
yeah.
what do you think?
I will be very cautious in terms of providing that response because, having had experience both from a private procurement perspective and from public procurement, and giving my experience in terms of being the compliance partner who is responsible for ensuring that the procurement department is compliant with the requirement of public procurement. It is always a tiny line in terms of, what is the difference. You will now, what I need to emphasize here is that when it comes to other areas that will give opportunity for disqualification, I need you to bear in mind that in a bid, bids and tenders are usually sealed and can only be opened when the bid period has closed and a date has been set aside for everybody to come for the bid to be opened. One of the key things that will happen prior to that time will be, one, if a bid is said, if the bid closure indicates that, if the bid document indicates that the bid will close at a particular point in time, take for instance, I have seen in decided cases where they say the bid must be submitted before 1 p.m. If the bid comes in 1:01, it should be disqualified because the bid document says it must be submitted. But there has been decided cases where it hasn't gotten up to 1:01. It was about 1:30. It was said that it hasn't also gotten to past 1 because it's still within the period of time. Another area will be where the company gives the contractor opportunity to correct mistakes they've made in their bid, especially if you stated in the bid document that once bid is submitted, you will not have opportunity of either making any amendment. Where you have said that in your bid document or invitation to tender, you will likely be breaching the fundamental principle that established contract A. So what I'm trying to say is that I have, in the course of my research, observed that a key issue that leads to a lot of angst in terms of relationship between vendors and company in a competitive bidding and tendering is, what is the information that the company included in their tender document? That is what drives it. So you have to make sure that every rule that has been set under the tender document that was published publicly for people to use it to provide their tender must be followed. So if you say in the tender document that once a bid is submitted, there will not be opportunity for any correction. If the vendor discovered there was an error before the end of the closure of the bid period, there is nothing that can be done because you've already said that there will not be opportunity for correction. However, if your bid document says there will be opportunity for correction, it is usually expected, just like they do even in an RFP, for you to give that vendor opportunity, but communicate that information to other people who have already bid or submitted their tender.
Yeah, that's a very good comment there. So, Afam, I believe you really exhausted that question. I have another question here, but though we really past timeline right now, we are 10 minutes past. So let me look at this question. So probably will be the last questions here. How many bid proposal is required for a competitive process in the public sector? What level of, okay, these are really basically procurement policies, so we won't be able to go into that. How about bid sent in the post but delivered late? This is a good question. Do we consider postmark date to make it a valid bid? So what we're saying here is that maybe the vendor already sent their bid, is on the way. I know there's a particular rule like that, that considered it to be valid. Is it valid in the case of contractual competitive bidding law in Canada?
I'll be glad to handle that question, and I will say it in this way. Like I did say, what the company states in the invitation to tender or the tender document, remember, is the guiding principle that establishes contract A. If you give opportunity to say that bids can be submitted, or if you give opportunity of ways that bids can be submitted, and you included putting it in the post through Canada Post, it is reasonable and reasonably expected that the company will state when the time period begins to count. Is it when it is received, or is it from the period that you submit it at the post office? I will give you examples from an immigration perspective. From an immigration perspective, in a country that I used to live in, that I once lived in, when you take, for instance, your visa is about to expire, or your visa validity or residence permit is about to expire on tomorrow, and then you send it out today, even if it gets to them in 2022, the date of submission is today, because that's the day it was postmarked. Because in their rule, they say that it is the day you actually posted it, that is the day it's deemed received. It doesn't matter when they receive it. So back to that question, and the answer to that is, it depends on what information that was provided in the invitation to tender or the tender document, and how that time will count. Will it count upon being received, or will it count upon being postmarked? That's why they said if it is electronic, make sure you send it before on the nip of time. If you need to submit, you must submit it to the person by hand, to that individual and no other individual. Any other question?
Okay. I think that's it. I don't want to keep people here when we're supposed to finish this within 1 hour. So
Abiola, if I need to quickly, I know I'm going to share this slide, but I need to quickly, rush through these ones, and then, give people opportunity to, get that from me. Okay. Here I talked about what are the remedies to a bidder. I have already talked about it. What will happen where and when the company breaches either the rules and the guideline for contract A, or awards a contract B without following the principles of contract A, because you can't deviate from the principles of contract A to award a contract B on a different principle. That's what this slide talks about. This also talks about remedies that will be available to the owner. There has been circumstances where a vendor, a contractor, submitted their bid, and they discovered that they made an error, or there was a mistake in the total value of the contract cost. And then at the end of the day, when they were awarded that contract, they kind of deviated from it. What the owner will do is to ask for remedies, and the remedies are being explained under this slide. I talked about what we need to know. This talked about what are the key things we need to know. And I need to emphasize here that competitive bidding and tendering cuts across both private and public. Not just public, it cuts across both private and public. More often, we have seen situations where private companies are being held liable for this because of the fact that they breach the fundamental clauses or terms and conditions that regulate or guide their contract A. Under the implications of tender and bid instruction, I talked about exclusion clauses here. That exclusion clauses, I've seen situations where companies will add exclusion clauses, what they will do, what they cannot do. What they are saying is that you cannot use exclusion clause to take yourself out of liability if you are breaching the principles or the rules that guides contract A, or you set a different precedent by issuing or awarding a contract other than the way you should have awarded it, or you are treating a non-compliant bid as compliant, or a compliant bid as if it is non-compliant. Exclusion clause will not save you. Who is impacted? I talked about it already, both private and public agencies. What are the risks that we are facing as a company? If I'm working for a company, what are the risks? As a procurement professional, what are the risks that we are facing? It depends on the risk profile of the company, what is the risk tolerance, and what is the risk appetite. But the key risk that I've identified here is legal risk, risk of being sued to court, financial, risk of the court awarding huge damages against you, reputational risk, people branding you as not being a good company or a good vendor, operational risk. If you have a project, that project will be stalled when there is a court action going on, depending. And there is also a strategy or strategic risk that is also involved. The next one will be benefit of competitive bidding and tendering to procurement professional. It will make you to become a subject matter expert. Like, I believe this slide, an opportunity for us to do that of public procurement will also be, it will save your company costs, because you are not just a subject matter expert, but you're also saving costs for your company. It will also give you opportunity to get entrance into public procurement. And I cannot emphasize, I have seen situations where people go for an interview for public procurement job and they fail because they do not have that knowledge. And I can say that it is easier to get into private procurement than going into public procurement. But knowing what are those key things that makes you stand out in public procurement are the things that will make you to be successful. And public procurement is usually that place where there are stiff competition and people do not have much knowledge in terms of what they need. Only few people have that knowledge. Then what are the key differences? I have emphasized what are the key differences between what is a tender and RFP. RFP. These things are too different. The key thing here that I've emphasized is that under a tender, there is no opportunity for a negotiation. But in an RFP, you are issuing an RFP in a negotiated manner, asking them to come in, and then you can have opportunity for you to negotiate. So if you issue out an invitation to tender or a tender document saying that you will be willing to negotiate, you're already breaching the rule, because in a tender, under competitive bidding and tendering, you are not allowed to negotiate. You must evaluate using the same criteria, and the principles of your contract A must be respected. Those are the things that I highlighted here. And I talked about my closing argument. The point is that we need to understand that there is differences between each of the cases. So for every competitive bidding and tendering, we have to look at them from a case-by-case basis, and then be able to understand what are the nuances that are involved, what are the things that we need to watch out for, and then be able to apply those things by looking at the nature of the relationship that is being created. This is not an opportunity to do what is called a peanut butter spread approach. You have to look at every incident, the way it applies, and what is applicable to it. I talked about my closing argument again, and I talked about questions. So I think I want to use this opportunity to thank each and every one of you. I know we've exceeded time, but I feel that, exceeding the time is for good purposes, because this is something that I feel that is very important and quite interesting. I will be able to, Abiodun and I will connect after this presentation for us to discuss how we can share the slide with you. The slide is, as like I can say, is something that I have to acknowledge. You will see in the slide that I acknowledge a lot of people where I did my research to avoid plagiarism, but this is also a copyrighted information, because this is my, my knowledge in terms of my intellectual knowledge as well. So based on that, I wish once again to thank you for this opportunity, and Abiodun will be communicating to each and every one of us who will be interested for us to take about more about public procurement, which I feel is another important field. Things about trade agreement. What is the difference between private procurement and public procurement? For people who are aspiring to go into public procurement, what are those things you need to watch out for? I remember going for an interview some time ago for a huge public procurement for a huge public agency, and I remember the question I was being asked. And now when I remember those questions, I keep laughing. Abiodun and I have shared that information in the past. These are the things that I intend to. What is it that will be beneficial to professionals who are aspiring to go into public procurement? And I can tell you that private and public procurement are two different things. And public procurement always have that edge because it's a specialist area. Thank you so much.
Yeah, thanks Afam. Really appreciate the opportunity to have you here. I mean, this is a lot of value added to us and the other guys who are there listening. It's a very important information that Afam shared today. I'm sure it's going to make a lot of difference for quite a number of those guys who have just joined us here in Canada. This is gold mine, guys. If you're going for any interview, this is definitely going to make a difference for you in terms of the knowledge you have in public procurement. Okay, so we'll follow up with this. Like I said earlier, we need to do a deep dive here. This is just like, we're just looking at this thing like from the top. There's a lot of things that are going on the back end as well. But we'll leave that only for those guys who are really interested and would like to really build a career in public procurement. And we'll be sharing the information very soon. Thanks, guys. Appreciate your time. Looking forward for us to network more. I believe we're gonna have an opportunity for that very soon, to meet the new guys and we'll see our face and know who the guys that we have in the group, who they are. And for those just joining us, I mean, who joined this event, but they are not members of Light Jobs Canada, well, you can reach out to us. We are on LinkedIn, and other social media. If you want to join, you can also go to our community website, which is on seraprojects.com, and there you'll be able to actually register to join the group. Okay, then that's for now. I'll see you guys. Have a great, wonderful week out there. Bye for now.
Thanks, everybody. Thanks, yeah. Thanks, everybody. Thanks. It was quite interesting. Yeah.
Okay, thanks, Praveen. Thanks, everybody. Bye for now. Catch you up later.